Well, when we last talked about Chapter 5 topics, we were discussing the case of Brown versus Board of Education of Topeka, Kansas, and a 1954 case that was heard by the Warren Court. Earl Warren was the Chief Justice of the Supreme Court starting in a recess appointment in 1953 by Dwight Eisenhower. He ended up having a huge effect on jurisprudence, coming up with the Miranda versus Arizona case, the Gideon versus Wainwright case, the Mapp versus Ohio case, and several others that affected law enforcement. But I don't know if any case had more of an effect on life in general than the 1954 case of Brown versus Board of Education of Topeka, Kansas, that was litigated by the NAACP, Legal Defense and Education Fund, and Thurgood Marshall was the lead attorney for the NAACP Legal Defense and Education Fund. He also litigated several cases leading up to Brown, including Sweat versus Painter, that was combined with the McLaurin case. So if any of this sounds unfamiliar to you, then I want you to go back and listen to my first lecture. But let's talk some more about the long-term effects, specifically on schools, public schools in the United States after the Brown case. As you can see, the process of integration was slow. And there was widespread resistance. In one of the clips in the last lecture, Ruby Brown was talking about people not liking change. And I think that in general is the issue. People get comfortable with an idea. They get comfortable with a status quo. They sometimes get comfortable with their position in life. And when you want to make them change, it is like trying to wean a little one from a bottle or a pacifier. They are going to fight, sometimes violently. They will scream, they will protest, and certainly that is what happened. So one of the things that did happen was people started moving. Well, let's just say it this way. Because of redlining, now I've introduced a new term, and that was where basically the federal government and the funding agencies systematically went through neighborhoods in the United States and started giving them grades. And if they were areas that had large poor populations, had large minority populations, whether or not they were poor, then they would say that area was undesirable and that the people there were not good credit risks. So they would mark the area and say that you couldn't give someone a loan. Banks could not give someone a loan, and they were not going to insure any loans in these areas. And make no mistake about it, they would go through, and I'll find a red line map for you and I'll post it for you in Blackboard. They would go through cities. They would find the affluent neighborhoods. The affluent neighborhoods would have this upgrade. They would find neighborhoods that were transitioning, They would give them a color code. They would find neighborhoods that were where poorer people lived, or neighborhoods that were predominantly black or predominantly Hispanic, and they would give them low grades. And banks got into the act. Real estate agents got into the act. There is a clip on YouTube where a real estate agent a guy that researched real estate agents in the city of Chicago said that real estate agents that showed black people, even if they could afford it, and certainly but black people that could afford it and that had good credit, if they showed them homes in affluent white neighborhoods, they would be fined. Banks would all of a sudden tell African Americans, if they were trying to live in if they were trying to buy a house in a neighborhood that was predominantly white or had been historically predominantly white, they would tell them that they were not approved for the loan. You had to find people that would finance you if you were African American, and you were limited in the locations that you could purchase. This was all over the place. This was I don't know how you can say if with the government involved, the loan corporation involved, it was anything other than systemic. And so if you have these neighborhoods that are segregated, have traditionally been segregated, it is fine to have a court order saying that schools can no longer be segregated. Okay, Brown versus Board of Education set that up, and set up a vehicle for people to sue and to have schools integrated. But you know that public school is based on zoning. It is based on where you live. You go to the school that is in where the school districts have zoned you, and they are usually close to your house. So if redlining led to segregation because of what schools people were zoned to go to, then the Supreme Court really kind of set out to help this problem, especially in locations and in independent school districts or school districts that had a history of discrimination. And so the way that states and federal governments and the Justice Department address this issue of what is literally called de facto, and that's because because of where people lived, there was segregation. It wasn't because there were laws still in place saying that the schools were going to be segregated, but it was because of where people lived. De facto segregation. Many school districts set out to basically force integration, and that was through the process of busing. So they would bus students out of their neighborhoods to other schools so that they could achieve more integration. But it was forced. And just like we saw those people screaming and hollering at Ruby Bridges and hollering at the Little Rock Nine and literally causing a riot at Mansfield High School, this did not go over well. And there were people that were being bused across town, and basically the same complaint that Linda Brown had, that she had to go across town to go to school because of the laws. These people were having that conversation because they were having to go someplace that was far away. And so there were demonstrations in Charlotte, North Carolina, Detroit, Michigan, Boston, dozens of cities saw people reacting to this forced integration. This is a famous picture. This was in Boston. And there had been an order of forced busing that was busing students from their neighborhoods to schools across town to achieve integration. And now notice in this picture, I don't see, the only black person I see is this lawyer that's being held. Um, and I don't know what they were planning to do to him. They saw a black face, they got upset. I guess they were going to impale him with the American flag. Um, and so right after this picture, the photographer started yelling, and they let the man go. He was not a high school student. He wasn't a teacher. He was actually just walking to work. But people were angry. Oh, all kinds of things was happening. A lot of southern schools would open private schools. They called them sex schools, and they would make them free for white students. So then you didn't have to go to school with black kids. Um, Many school districts just resisted. And then there was the famous, well, if I'm not in the school district, then you can't you can't force me to go to someplace across town. And the phenomenon was called white flight, where people that did not want to have to deal with these African Americans coming to their schools or their children being bused to schools across town would just move to smaller communities that were predominantly white and move into the suburbs. And so we call it white flight. And so none of you have to go across town if you're in a small town and the town is full of people that you find desirable, then you don't have to worry about district lines, because you don't have to worry about school districts, because they can't bus you across district lines. They can't integrate Prosper and Denton. So we started to see smaller communities being built up by people that were leaving the large cities, where they were seeing the busing going on, and they were not happy about it. So this stops in 2003. This one is pretty old, but I still like it. I pulled it from another book because I like the images. So just notice, and we'll just look at the yellow line in the South. And so the question is the point at which maximum desegregation was achieved. So we start in 1968 in the South. 80%, more than 80% of students went to segregated schools, I'm sorry, where there were predominantly all whites or only all whites, or predominantly blacks or only blacks at schools. And so then they started to pass busing requirements, and you see that there was a sharp decrease in students that were going to segregated schools. 1988 is the year I graduated from high school. 1988 is also the year that busing was at its height. And even then, even with all that effort and that forced effort, the number of students going to, the percentage of students in the South that were going to segregated schools was still more than half. But that then in 1991, there was a case that made it to the Supreme Court. A school district had been sued, and they finally said, okay, if you have consistently made an effort to desegregate, then we are no longer going to require the Justice Department and the Education Department to force you to bus. And so as soon as the regulation, the requirement went away, and I really believe that in the heart of hearts of people that put this into action, what they believed is that people would get to know each other, and that the benefit of that interaction, because there is benefit in interacting with people that come from different backgrounds. There is. But people were just too resistant to really see the benefit. And so as soon as the courts and the departments stop enforcing it, then the schools stopped doing it. And little by little, and again, this stops in 2003. If we were looking at 2020, it would be almost back up to where it was in 1968, y'all. Our public school systems are almost as segregated as they were before, as they were in the 60s. And some of that is because of white flight and people stayed. Some of it is because the neighborhoods stayed intact. So those red line neighborhoods never really became integrated. So it's just straight zoning. It's more de facto. And those are two factors of many that have led to our schools being even more desegregated than they were even in 2003. So let's talk a little bit about court action. So if I'll say it like this, if there is an allegation that you are affecting someone's religious freedom, if there is an allegation that you are deliberately or by default affecting or separating someone because of race or national origin, then whatever governmental entity passed that law, or whichever jurisdiction a private company is in, they are going to have to show a compelling reason for having that rule or that law. And so we call this the strict scrutiny test. If a person is in a suspect classification, and that basically is race, national origin, or religion, then it is very hard to justify something that separates that group out, that marginalizes that group. And so the burden is completely on the government to show that they have some compelling reason. And for this reason, most of the time, if it involves race in any way, it gets struck down. Every now and then you can show your compelling reason, but it is very, very difficult for the government to win if there is a separation because of race, national origin, or religion. The same is not true if there is a difference because of gender. If the difference is because of gender, then we call that intermediate scrutiny. Intermediate scrutiny. This is something that Ruth Bader Ginsburg fought for many years as an ACLU attorney in their gender or sex law division. I can't remember the name of the division, but she basically invented it and created a division of the ACLU that dealt with gender discrimination, and really fought to have gender up into that top strict scrutiny. But the courts never did say, yeah, unless you can show a compelling reason, government, you can't justify discrimination on the basis of gender. So if it is gender related, it's a gender related policy or law, then you just have to show that there is something that is substantially related to the achievement of important governmental objectives. So it's not like almost automatic, like strict scrutiny. You're going to have to, there's more of a burden on the person that is suing because of gender classifications than there is. And they basically split. The government and the person that is suing split. That's intermediate. Then there are those like age discrimination cases. Sexual orientation discrimination cases that basically the test is not strict, not intermediate, where there's shared responsibility, but it's called reasonable basis test. And so it is actually okay to have inequalities based on age. But the only thing that the government has to show is that it's reasonably related to a legitimate government interest. It is difficult to win an age discrimination case because the amount that has to be proven by the defendant is so high, and the amount that has to be proven by the government that passed the law is very low. So those are the three categories. Strict scrutiny is race, national origin, religion. Intermediate scrutiny is gender, and everything else is reasonable basis. I'm not saying that you can never win a case, because there is always the possibility that they cannot show a reasonable reason that they passed a certain law. But it's just much harder. So this is a chart from the book, and it talks about the 3 levels of scrutiny and repeats what I just said. If you're not in a suspect category, then it's reasonable basis. If you're in an almost suspect category, and literally the only thing that I know that falls into that niche is gender, then you split responsibilities between government and the plaintiff. And if it is race, ethnicity, and I always keep throwing in religion, and I always will throw in religion as well, then it's strict scrutiny. So, as we were seeing, the last clip that I showed you in the last lecture was in 1960. That was Ruby Bridges. The Little Rock Nine was 1957. The Mansfield riots were 1956. The case of Brown versus Board of Education of Topeka, Kansas was heard in 1954. The ruling in that case said that schools needed to desegregate with all deliberate speed. Nobody knew what that meant, and because the requirement was that you had to, if you wanted to see your schools desegregated, sue and bear the expense of having the suit filed to get the court order. Meanwhile, public accommodations were still segregated. They were segregated with court approval. There had been a case that had overturned some of the last Reconstruction Acts, and it said that you cannot require private businesses to set different policies. They can refuse entry to anyone they want to, and if that happens to be someone that is of a certain race, that is a decision that they get to make. And that was reinforced in Plessy versus Ferguson, 1897. So this was the way that things operated mostly in the South. It was certainly more pronounced in the South. It was a lot more subtle in the North, but there were places that you knew you couldn't go. We talked about the Green Book, and I showed you that even in northern cities, you still needed to know your way around and needed to be able to navigate the places where you were not welcome. Or let's say it in a positive way, the places where you were welcome. So when Lyndon Johnson got in his head that he was going to continue the work of John F. Kennedy, he set about having legislation introduced that would allow all persons to equal access to public accommodations, with the argument that if you were open to the public, you were engaged in interstate commerce. Interstate commerce is under the purview and under the regulation because of Article 1, Section 8 of Congress. And so Congress could order you to not discriminate, require you to have some policy in place that was not discriminatory. And so the Civil Rights Act of 1964 said that medium and large firms couldn't discriminate on the basis of race, color, religion, sex, or national origin in hiring, in promotion, and wages of employees. It also required schools that were still segregated. And make no mistake about it, in 1964, there were several schools that were still segregated. 1968, there were several schools that were still segregated. Remember the busing graph. But they started saying they were going to withhold funds, money, from schools that were still segregated. So schools started to desegregate in the late 60s. 67, that's when Rockdale High School and ACOC, which was the name of the all-black school, desegregated. 1968, 1969, schools desegregated. In Texas, it was in 1970 when a federal judge said, if your school's still segregated, you're that stubborn, you're you're foregoing your federal aid, you're gonna have to desegregate now. 1970. That's the year I was born. So that was 50 years ago. There are some forms of discrimination that are technically lawful. Um, so like church related schools can take religion into account when deciding on hiring teachers. A public school can't do that, but a church related school can. So what led to such sweeping legislation? Legislation that eventually started the Equal Employment Opportunity Commission under the Justice Department to investigate allegations of discrimination. How did we get there? How did LBJ get to the decision that it was pretty much time to force the hand of those that were slow rolling the institutions of segregation? Well, one of them was civil rights leaders that caught Lyndon Johnson's eye. People like Dr. Martin Luther King Jr., who was the leader and founder of the Southern Christian Leadership Conference, and negotiated with Lyndon Johnson to have the March on Washington for Jobs and Freedom. He was among several and was the keynote speaker at the March on Washington. There were civil rights demonstrations all over, many of them led by youth, like and an even larger and more influential movement by students led by people like John Lewis, the late John Lewis, Clive Davis. There were several youth or college age students that were instrumental in the movement as well. And there was incident after incident that was really catching people's eye. Let's talk about a couple of them. One of them was the Rosa Parks incident in Alabama. So Miss Parks was, make no mistake about it, Miss Parks was trained. She had been trained in civil disobedience. She was part of the African Methodist Episcopal Church, and if you recall from the Many Rivers to Cross movie, that church was the first black church that was started because there was so much discrimination within the Methodist Church, and so just a lot of activism within the church and a lot of civil participation that is encouraged by the African Methodist Episcopal Church, the United Methodist Church, and like Martin Luther King, who was Baptist, the Black Baptist Church, all encouraged participation, making things right. And Miss Parks really quietly protested a law, an ordinance in Montgomery, Alabama. The ordinance basically said you have to, if you are black or colored, I think was the word that they like that they chose and wrote into the legislation. Um, and you rode on a city bus, then you had to fill in from the back of the bus. Um, and so you kept filling in, um, but whites filled in from the front of the bus. And if ever there was a time when the front of the section where the African Americans were and the back of the section where whites were filled, then African Americans were instructed to get up and give their seat to a white person. So Miss Parks was sitting at the front of the black section, and a white gentleman came on the bus. He walks back, and there he sees Miss Parks, and he tells her, you're gonna have to get up," which was what the law was. You're gonna have to get up. And Miss Parks just quietly said, "No, nope, I'm not getting up," which was a violation of the law. The bus driver went berserk. The bus driver stopped the vehicle, and eventually Miss Parks was arrested for violating the city ordinance. Now I don't know if I've told y'all this before, but my grandmother and my family is from Alabama, and my grandmother swears, rest her soul, she passed away uh, right before her 100th birthday. Um, but my uncle has verified that Rosa Parks is my cousin, distant cousin. Uh, and so when she refused to get up, she was eventually arrested and taken to jail. Was Rosa Parks the first or even the only African American person that had defied what we can agree in 2020 was a ridiculous ordinance? No, she was not. Um, but she was the right person at the right time. She was quiet. She was pretty. She was fair skinned. She was respectable. She had a good job. Um, and so, when Dr. King approached her and said, "Look, we think that we want to do something with this. We want to protest what happened to you, and we want to make you the symbol of what we're going to do." Miss Parks said yes. She said that's fine. And so she became the face of defiance, of quiet defiance. And what ensued was a boycott of the bus system in Montgomery. I mean, black people would not get on the buses. They were not riding the buses, and they were the primary users. And so, of course, revenue from the bus system went down tremendously. What did people do? They walked to work if they could. Sometimes their employers would pick them up. Sometimes their friends would pick them up. They organized carpools where people would use their private cars. They would drive. People would stand there. They would come and pick some people up. They would take them to work. Then they would come back. And so they basically devised a transportation system, a private transportation system, to make the point that we will not be riding your buses until you stop this ridiculous policy. And this lasted for weeks, and there was pressure from the federal government. It was making the city look horrible that they were so stubborn. Um, and eventually they negotiated and agreed to end the policy, and the boycott was over. It got lots of attention, lots of attention. Rosa Parks became a household name. Martin Luther King became a household name. And it led to a series of other protests. So there, what some of the things that were common. This is a picture of sit-ins. This is a pretty famous picture. So students, and it was mostly college students that would be involved, not always all black. Notice the picture. They would go and sit at locations that still had segregated counters, lunch counters, and so they would just sit there with a black person, and oftentimes they would gather crowds that were not happy about what was going on. Now, this young lady right here is Jean Mulholland. And Jean Mulholland was a freedom rider. She was very active in the civil rights movement and civil rights protests. And she just happens to be the first non-black member of my sorority. My sorority is Delta Sigma Theta, and she is a member of Delta Sigma Theta. She was down for the cause, and we're very, very proud to have her as a member. These young people are getting ready for a ride along. They would get onto Greyhound buses that also had a desegregation policy, and the buses, and basically sit anywhere they wanted to on the bus, and it would make people angry, and people would show up when they were getting ready to go on. There were protests, there were people throwing Molotov cocktails. I know of at least one person was killed, and it was simply because the young people were trying to end the discrimination policy, or policy that they thought was unfair. Oftentimes, the demonstrations would bring out law enforcement. They would bring out fire departments, and there are some pretty famous photos of fire departments turning water hoses on young people, police dogs attacking young people, and everybody was trained not to react. It was called um, basically peaceful demonstrations, and they were trained not to react. And these made for some powerful images. When we talk about the media, just think about how that looked to people that were not there, to people in the North, to people in other countries. It was like, how can you be that cruel? How can you um, how can it be such a big deal to you that you are willing to turn fire hoses on kids, and to let dogs attack or seem to attack children and take people to jail? Good heavens, how many times did John Lewis go to jail? He went to jail just about every large city that he went through as he was doing his participating in sit-ins, and he did ride-alongs as well. This is a picture of the March on Washington. This is a very narrow shot, or is this Selma? This may be marching over the bridge in Selma, Bloody Sunday. So the Civil Rights Act was huge and it was sweeping. It addressed a little bit about voting discrimination, but not. It was not very specific. Was not very specific. So in 19 we had the Civil Rights Act that was passed in 1964 or signed by the president in 1964. The 24th Amendment had been winding its way through. It had received 2/3 vote in Congress, and then 3/4 of the states had approved it. And so the 24th Amendment outlawed poll taxes. Then in 1966, the Supreme Court banned literacy tests. But remember that the Reconstruction Amendments, 13th Amendment, which abolished slavery, the 14th Amendment, which gave guaranteed due process and equal protection of the laws, and the 15th Amendment, which gave the right to vote to people regardless of their previous condition of servitude or their color. But Southern states in general had been allowed to, as part of their Jim Crow systems, write in voting restrictions. So some of them were on the books, some of them were more subtle, like they would just close the office when people came to vote. But in general, states were doing all kinds of little odd things. Texas had a white only primary. And so Democrats were basically running things, and the primary is where you decide who is going to actually be the candidate. Well, many states, Texas included, had laws that said only whites could vote in the primaries. You could vote in the general election, but you couldn't vote in the primaries. If you wanted to register to vote, you had to pay some money. Registration or poll tax would happen in January, and you had to register every year. Some states had what are called literacy tests, where you had to pass a test, a written test usually, to be able to register to vote, and the questions that were asked were different. Some states were seeing that this was also affecting whites, and it was certainly meant to address blacks voting, which was a big fear, because blacks usually have African Americans have a tendency to vote in large blocks. We can talk some more later about why this is, but vote in blocks, and it increases voting power, and it was freaking the leaders that had gotten used to the status quo, traditional, it was freaking them out. So they were trying to figure out ways to keep African Americans from voting. Literacy test, grandfather clause. So if your grandfather could vote before 1865, which was the last year of the Civil War, then you can vote. Good moral character clauses. The basically the registrar could decide whether or not you were a good moral character and would let you register to vote if you were, and you couldn't register to vote if they wouldn't certify that. There were a myriad of things that were going on that were meant to disenfranchise African Americans. So little by little, these things were being knocked down, either through constitutional amendment, through Supreme Court decisions, or through the Voting Rights Act of 1965. So the Voting Rights Act of 1965 basically set up the federal government as a watchdog and an overseer of state election laws and practices and redistricting. So if you were a state that had a history of one particular group, and at first it was only African Americans, that was certainly expanded over time, but at first it was only African Americans. So if you have a population of African Americans and less than 50% of the vote, those that are eligible to vote, are voting, then you went onto this list. And I think I've talked about it before, but I'm just going to reiterate that the Voting Rights Act put states like Mississippi, Georgia, Alabama. It was mostly southern states in 1965 that went on this list, and so if you were on the list, you were going to have government oversight, Justice Department oversight, and they would assign federal judges to look at your voting laws, to look at your maps when you redistricted, um, and tell you whether or not that was going to have a disproportionate effect on African Americans. In 1975, Texas was added to the list, not because of the voting uh, population, the voting numbers of African Americans, voting percentages of African Americans, but because the percentage of Hispanics, which the Civil Rights Act was expanded to include, was so low. So Texas was added. States like South Dakota were added because of their percentage of natives in their states were so low. So there were some states that were added because there was evidence of discrimination in voting and voting registration of a suspect class, mainly someone that was of a race or class or national origin that had traditionally experienced discrimination. And so that really went on. The Voting Rights Act is still good law, but in 2013, in a case that was brought really technically by the state of Alabama, Shelby County. Shelby County is a county in Alabama, and Texas Attorney General joined this suit. Holder in this case was Eric Holder, who was the Attorney General of under Barack Obama, and they sued and said, "You're holding us to this standard and putting everything that we're doing under scrutiny based on numbers from 1965 and formulas from 1965. So there is no proof that this discrimination is still going on. And so how can you just continue to renew and continue to restrict us based on 1965 principles?" Now, mind you, they offered absolutely no numbers to show that if the restrictions ended, that there would not be. And I mean, how can you? But what the Supreme Court did was said not knock down the Voting Rights Act, but they did say Congress is going to have to come up with a different formula for deciding who is going to be under voting rights restrictions, this automatic review. And so when they did that, they basically said until Congress does that, there will be no automatic review. And when I tell you that states have been off to the races, passing all kinds of stuff, or all kinds of laws that may be found to be discriminatory, and with this Supreme Court may not. And just kind of holding their breath and proceeding with acts that are clearly or very apparently discriminatory, hoping that they'll get through this next voting cycle before somebody says, yeah, you can't do that. And for the most part, the Supreme Court, when they get these cases, they're going, the state can decide. Y'all do what y'all want to do. Kind of like they did in 1897. Y'all do what you want to do. Also under Lyndon Johnson was the Civil Rights Act of 1968, also known as the Fair Housing Act. This addressed specifically some of the redlining issues that I was talking to you about before. Let's see if this video plays.
Home ownership, the means by which most Americans begin to generate familial wealth. Unbeknownst to most, there was this little big thing called redlining, which was engaged in by the U.S. government, local realtors, and lenders in determining who got to realize this so-called American dream. What's redlining, you ask? Picture a classroom full of students that are prepping for an exam that they must pass in order to get to the next grade. 85% of the students get to come into class every day, are given extra materials to go over, and can meet with the teachers to make sure they understand everything on the test. The remaining 15% get no assistance from the school whatsoever. By the time the test comes around, who do you think has the overwhelmingly better chance of getting to the next level? That, my friends, is how redlining works. In the 1930s, the Homeowners Loan Corporation, HOLC, joined together with local lenders and realtors and set out to evaluate the mortgage lending risk of 239 cities across the U.S. When the HOLC evaluated the cities, they attached letter grades A through D to neighborhoods based on a myriad of factors, with race being the preeminent one. Black areas systemically scored poorly, white areas scored well. According to the U.S., they were solely looking to loan capital to areas that were considered strong and potential of returning that investment. Yet, at the same time, they also claimed to be guarding against, and I quote, the infiltration of foreign-born, Negro, and lower-grade populations. For 20 years, between the 1930s and 50s, 3/5 of homes purchased were financed by the FHA. Realize, of that number, 2% of FHA loans went to non-white homebuyers. Redlining was practiced en masse from the 1930s to the 1970s. Just to realize how ridiculous this situation was, go and research the Burwood Wall, a 6-foot-high cement wall built in 8 Mile, Detroit that split the black area from the white area. Once the developers created this wall, the U.S. government agreed to fund their project. If you take a look at the historic redline maps of cities across America, and then take a look at the neighborhoods within those cities, there's no question, the evaluators were visionaries, whether for good or for worse. To this day, those neighborhoods still represent the most poverty-stricken areas in all of America.
So the Civil Rights Act of 1968 prohibited redlining. And just as the video just said, this was a refusal to give mortgages for homes in certain neighborhoods, primarily those with large black populations. Today, 2020, there are still strong patterns of housing segregation. African Americans and Hispanics still have more difficulty obtaining mortgages than whites of comparable income levels and even comparable credit scores. There have been several. I know that Countrywide was sued because they were denying African Americans and Hispanics in larger numbers, and it really kind of seemed like it was based solely on their name, but they were denying more loans, even, and this was 2011 or so that suit was heard. This is a red line map of the city of Austin. Here's the legend. Green was best. Blue was still desirable. Yellow was definitely declining. And red was hazardous. If you know anything about Austin, and I know a little, Eastern Austin, was the area of town where a lot of African Americans lived. And notice that it is red lined, hazardous. So you were not going to be able to get a loan to live in that house, to live in that area. You were going to have to find other means, which also made the house values in the area very low. Now, this is a really good example and a very clear example, because some maps are really hard to read, but a very clear example of the Home Loan Corporation red line maps. And it was widespread. So this concludes this section. It went a little longer than I wanted it to, but that is going to end the equality through law section. We'll, in the next lecture, talk about continuing struggle, and then we will end with affirmative action.